Hello and welcome to Heal 6825. We're going to talk about legal issues and also disclosure today. And the slide deck actually has quite a number of slides that you can read through. I'm going to highlight a couple key concepts today for our discussion. So first of all, one distinguishing factor is patient safety as opposed to the legal system. So up to now, we've been talking about patient safety and quality, which avoids placing blame on one or two people because there's system issues. It encourages transparency to problem solve, learn all sorts of things, and also to problem solve with patients. Um, the legal system, on the other hand, and I apologize for this slide. My son made it a long time ago when he was a little guy. He helped me animate this, and I keep forgetting about it until it comes around. So let's go through it. Okay, so the legal system focuses on ultimate responsibility or blame. There's a plaintiff versus defense mindset. The patient's usually the plaintiff, the defense is usually the hospital, including nurses and the physicians. And then there's also peer review, which we use this for patient safety so we can study things. It outlines what is admissible in terms of incident reporting. For example, if you're in Illinois, the rules are much stricter than in Wisconsin or Indiana or some other state. So you really have to look at that. But the overall piece is it tends to discourage open information sharing, which we know from the patient safety perspective doesn't get things fixed. But today we're going to talk about the legal system and a little bit about disclosure. We already talked about criminal acts versus negligent acts. We're going to talk about malpractice, which again means that you don't mean to do something. So you might see this in other areas, and you might have seen this before, but basically for negligence, which is not a criminal act, it's just a mistake, you have to have 4 elements to prove it. One is duty, that you have the responsibility to act. One is breach, that you did something wrong to breach that duty. The breach of that duty then has to cause an action like a fall or incorrect medicine, and there has to be some damage. So the link caused harm. So you have to have those 4 elements. So for example, if I'm a nurse and I give, let's say, Tylenol instead of Advil, I give the wrong medication, but let's say the patient did just fine. I did have a duty to give that medication. There was a breach, but it didn't cause any damage. And sometimes it's very complex to tease out different elements because patients suffer from bad outcomes. But basically, you have to have something that caused that damage. So, for example, if you have a patient who bled after surgery, but everything was done right, there's no negligence or cause that links that to the damage. That was an expected outcome. So you really have to sort through all of these things. The thing is, for this, you need all 4 elements, and we talked about the Tylenol versus the Advil. But a patient can bring an action even if it's clear that harm has not been caused, and then you have to sort through kind of what happened. And for medical malpractice, the type of negligence that you look at is, would a reasonable practitioner do the same thing? Kind of like the substitution piece we looked at in Just Culture in the same sort of case. And there's an example there for you to take a look at. Now, there is an exception, res ipsa loquitur, the thing is what it is, and you don't need experts for that sort of case. So if you leave a retractor or a sponge or something like that in a patient, you don't need an expert to tell you that shouldn't be left in there. So that's one of the exceptions to the rule. Sometimes the patient has responsibility as well, so it's called comparative negligence. So maybe the patient got the wrong medication but didn't return for follow-up. Or maybe the patient was supposed to return for follow-up and didn't, and something could have been mitigated. So that might be an example of comparative negligence. Now you have to be careful because you never want to blame the patient, but the patient does have some responsibilities. So you can have different damages, economic, which is financial kinds of things, and non-economic, and states have different limits for these. You can also have punitive damages, and usually we don't see this in malpractice cases. So when you look at incident reporting and patient complaints, so you look at not only in terms of quality improvement, but you look at incident reports and complaints for a particular case. So if an incident report is filed, what did the provider do to help or mitigate? Or if a patient complained about it, did the organization really try to work through it and help? Sometimes, even if a hospital did something wrong, or healthcare system or provider, we'll talk a little bit about disclosure. Sometimes there's ways to work with the family to prevent filing a lawsuit through insurance or other things like that. So patient complaints are a great way to help resolve issues. You want to hear them. Sometimes they're difficult to hear, but you want to hear them because then you can address them and hear what's going on. And actually, for hospitals, the CMS conditions of participation have a process to resolve complaints and grievances, which are most patient complaints. And it's a very set, stepwise rules that you have to follow that CMS will come in and take a look at. Now, one thing that's a very important topic is patient disclosure. And a couple things. Patient disclosures are talking to patients when an error has occurred. And sometimes disclosure is a sensitive words for different providers. And really, when you think about it, it's a discussion. A disclosure is typically led by the attending physician, supported by nursing, risk management, legal, whoever, hospital administration. But one thing, make sure you don't do a disclosure on your own. If a patient wants information about an incident, say you'll get information and check on it and do get back with them. When you think about disclosures, a lot of times people will think about a really severe sort of error, and so if somebody operated on the wrong knee, that's pretty obvious. But sometimes it can be a more subtle thing, and the ethical organization does sit down with the patient and discuss these sorts of things. And the rule of thumb usually is an unanticipated outcome, so something you didn't expect. Now, a lot of times providers will do lots of little disclosures, maybe the Tylenol and the Advil example. That would be something that certainly the floor could handle. But some of the more complicated ones, again, check your hospital policies and procedures to see what to do. Some people worry that disclosure increases litigation, and in fact, research shows that litigation does not increase with a good disclosure program. So disclosure really is a discussion. It's not necessarily the admission that something went wrong. Sometimes patients will think they've had a bad outcome, and the hospital, health system, what have you, will review it and everything went right. It was a poor outcome. So it's really a discussion about how care was reviewed and what the findings are, in conjunction again with your healthcare system and what the state requirements are and the policies and procedures. Always do check what's the standard in your own organization. So typically a disclosure or discussion includes the patient or the family or whoever sharing concerns, an apology that care did not go as the patient expected, or in some cases went wrong. And this is another area to check because Some states have rules that you can apologize to a patient. Other states take apology as an admission of guilt, so you have to be careful. But typically, apology is okay depending on your state. What happened in the care? And you do have to work with your organization, because if it's a peer review matter, there are just certain things you can share. Um, the disclosure will ask how the hospital health system provider can help, and referral to the hospital insurer. Again, it's usually led by the attending physician, sometimes the chief medical officer. If it's a nursing issue, the chief nurse or whomever. But again, do check the rules. I can't be strong enough in advising that, but in general, be aware that disclosure is the right thing to do in general, and is considered a best practice. So here's the four hallmarks from IHI: immediacy, transparency. However, you can't disclose what you don't know. So, for example, if it's a complicated incident and it's going to take a lot of time to figure out what happened, you let the patient know you're looking into it, and we'll keep them updated. So it doesn't. The immediacy is getting together with the family. There's a video here that if you could take a look at, I think would be great. It's Linda Kenny and her story around her journey with disclosure. A word about insurance. Hospital and healthcare systems typically carry insurance for nurses and providers. It's interesting, bedside nurses are considered a part of the hospital, so they're not sued individually. If they're named, usually the insurer, the attorney will get the nurse's name off the suit. Nurse practitioners, though, are considered providers, and they're named individually. Some systems are self-insured. They have captive insurance companies. There's all kinds of different arrangements. Know how you're insured in your workplace and who to notify if something does occur. For lawsuits, the basic stages are filing a claim, serving a summons, meeting with the defense attorney. There's a discovery process, expert witnesses in most cases, and then a trial, although a lot of times cases are settled. And in general, if you look at statistics around the country, people worry a lot about lawsuits, but actually lawsuits have been going down nationwide, and we're not seeing an increased frequency. But it's good to know how these things work. Filing a claim, you can read into that. Discovery, and then resolution. So sometimes, again, more typically, a suit will be settled in different cases. There's also different laws around quality, around complaints and incident reports, how things are protected. So look into that in your own state. And there's other regulatory matters as well. The federal government and CMS shape the standard of care, as well as the state government, which work together, and accreditation bodies too. There's a state regulatory system, there's state practice acts, the Department of Health, the Joint Commission, which not everybody uses. Some people use the DMV, which is an alternate piece. Now, one last thing before we close, how do you read law for clinical practices? So basically, review the law if you're looking at a policy, or have somebody help you, maybe the legal department, wherever you are. You look at the federal and the state law, look at regulatory requirements, look at different standards of care from professional bodies, and then curriculum if it involves a practice. And then after review, determine the policy and practice. And actually, it's good to get policies from other organizations as examples to help guide you, because sometimes it's easier than reinventing the wheel. So people worry about these things. I'll let you read it. And we're going to close with that today. Take care and have a good week.